Welcome to the City Club of Eugene's March 17th, 2023 program, Guilty Until Proven Innocent, the work of the Oregon Innocence Project. This is the 22nd program of our 2022-2023 programming year. My name is Karin Knudsen and I am City Club's president. The City Club of Eugene comes to you live today from the Fifth Street Market District in the heart of downtown Eugene. Welcome to our invited speakers, Kenneth Kruschner and Lisa Kristen, as well as to all of City Club's members and everyone here with us and listening. It's a pleasure to have you here as a part of this community conversation. For almost 30 years, the City Club of Eugene has remained committed to its mission to build community vision through open inquiry by providing weekly programs that offer the opportunity for community members to learn together and from differing perspectives. With their participation, City Club members and speakers model civil and inquiring engagement, which supports our community's efforts to better engage the important and sometimes difficult issues before us. Now more than ever, this open exchange of ideas and information is critical to the future and health of our communities and to all communities. City Club creates the space for civil discussions of civic issues, and we invite you to join us every week and to hear directly from local, national, and international experts on a broad range of local issues. We cannot do this work without support, and we are so grateful to the core of volunteers that make City Club possible every week who lead our organization, and also to our business and in-kind sponsors. Support for the City Club of Eugene is provided by our members and both business and in-kind sponsors, including our diamond sponsors, Kaiser Permanente, the University of Oregon, Peace Health, and Lane Community College. And we appreciate support from the City of Eugene and Lane County as well. Whether you're with us for the first time today or a longtime listener, if you value these community conversations, we invite you to support them by becoming a member at the City Club of Eugene's website, cityclubofelugene.org. And lastly, if you're with us in the room or watching and listening, we encourage you to ask questions of our speakers during the Q&A period following their remarks. I'd like to thank Joel Corin for coordinating today's program, and now I'll invite Joel to the microphone to introduce our discussion and speakers.
Happy St. Paddy's Day, everyone. For a number of years, I practiced criminal law, and nothing caused more fear in a defense attorney than the thought that one of his clients, who was actually innocent, would be convicted. Nothing offends the sense of justice as much as an innocent person being incarcerated or killed for a crime that he or she did not commit. We want the justice system to be rigorous and equitable. But every year, we hear about people being released from jail after long incarceration because new evidence conclusively proves their innocence. Today we are joined by two speakers from the Oregon Innocence Project who engage in that complex and noble work, Ken Kruschner and Lisa Kristen. Kenneth Kruschner is the Oregon Innocence Project managing attorney, responsible for litigating and coordinating Oregon Innocence Project cases alongside staff and volunteer counsels, paralegals, investigators, and law students. Lisa Kristen joined the Oregon Innocence Project as a volunteer staff attorney in 2018. Since then, Lisa has reviewed and investigated cases for the Oregon Innocence Project, as well as advocating for Oregon Justice Resource Center and on juvenile issues. Our first questioner today is Garrett Epps, who is a professor of constitutional law at the University of Oregon Law School. He's also taught in Baltimore and at the American University, Boston College, and Duke University, and has written a couple of novels. So now I'll call upon Kenneth Kruschner.
Is it afternoon? It is. Good afternoon. My name is Kenneth Kruschner. I am the managing attorney at Oregon Innocence Project, OIP. I've only been at OIP for about a year or so. OIP has been around for around 8 years or so. Prior to being with OIP, I did capital death penalty cases and criminal cases, everything from violations up to felonies, trial, direct appeal, post-conviction relief. Joining OIP as a managing attorney was a dream job for me, because much of what OIP's work does is, in many ways, we are the place of last resort for folks in prison. Folks write us or call us and ask for help. Most of our inquirers, that's what we call potential clients, have been in prison for decades or for years at least, and the system has failed them. There are folks that, in their view, saying they're innocent, and they've maintained their innocence throughout the entire process, through pre-arrest, during arrest, during the trial phase, when they're in prison, sometimes in parole hearings, if they're old enough where they committed their crime before 1989, where Oregon still had a parole system. And that parole system continues for those guys. And they've maintained their innocence the entire time. And of course, some folks may be falsely maintaining their innocence, but many folks have maintained their innocence because they don't understand how the whole system failed them and how the process failed them, and they are in prison for something that they didn't do. So they call us, and we look at their case, and we have oftentimes a heavy weight. We oftentimes have a heavy weight to bear, thank you, where we're looking at cases that are decades old, or many times where we have to contact and collect information that's difficult to collect, getting information from prior counsel, from law enforcement agencies, from the courts, and trying to figure out what happened and how the system did fail them. In general, in cases where there have been exonerations, there's a handful of different common characteristics of common causes for wrongful conviction. I thought I would just run through and kind of talk about some of those common causes for wrongful conviction and can talk about them in relation to some of our cases. Now, you have to remember that as a lawyer, I'm limited in some of what I can talk about with cases. There's some cases where we've successfully gotten exonerations, or we're in the process of litigating them, where our clients have authorized us to talk about them publicly, and there's some cases where we cannot do so. So, one of the most common kind of classic and innocence cases cause for wrongful conviction is generally thought of as bad forensics. So bad science was used. These cases, kind of the most famous examples are cases where bad DNA was used or DNA was not used. And years later, when folks look at the cases and can look at the evidence and re-examine some of the evidence, we're able to determine through more modern techniques of DNA that the evidence that had been held up as being inculpatory, as being evidence of guilt, is actually exculpatory. That is evidence of innocence. A classic Oregon case that involved this was a murder case where essentially the person was convicted mostly on the strength of a forensic scientist's looking at the bullets that were found at the scene of the crime where the dead body was, and then compared those bullets with bullets that were found in the defendant's home. And they did a forensic investigation of them, and scientists got on the stand and told the judge and jury that the bullets that were found that were associated with the decedent, the dead body, were identical to the bullets in the home. Well, what Innocence Counsel learned years afterwards was that in the process of that case, that law enforcement, the Oregon State Patrol Laboratory, would not perform that sort of inquiry, that sort of comparison, because it wasn't scientifically valid. So law enforcement actually had to secure their own private forensic scientists to perform that analysis, present that evidence to the jury that was used to convict. Years later, Innocence Counsel was able to perform further forensic investigation, get their own science, and describe to the judge how that science was unreliable. And essentially, the strongest piece of the prosecution's case fell away in the light of good science. There's oftentimes also false confessions that are involved in innocence cases. In Oregon, we have not had an exoneration that's based on false confession outside of cases where folks plead guilty. Now, places where folks plead guilty are similar to false confession cases because, of course, when they're pleading guilty, they're essentially confessing to the judge that they are in fact guilty. And it's a question for folks again and again why anybody ever would falsely confess. Right? Most people probably in this room and listening at home may think to themselves, God, I cannot imagine any situation where I would give a false confession. What I would like to assure most of you is that when faced with some of the circumstances that have been presented to other people throughout the country that have falsely confessed in their case, that most of you assuredly probably would falsely confess if faced with those same circumstances. Those circumstances oftentimes are presented as extreme coercion, being interrogated time and time again, being presented essentially with the opportunity to make the interrogation stop if they just gave the police a false confession, matched with a belief and assurance that even if they did give the police a false confession, that would come out in the wash of the court system and they would ultimately be exonerated. Also, in many false confession cases, there's cultural barriers where folks are coming in and not quite understanding what is about to happen to them after they give a false confession. Essentially, what they want to do is they want to get out of the situation at hand and with a trust that the system will somehow work its way out afterwards. Or also, in context of guilty pleas, folks oftentimes give false confessions in the context of the guilty plea because they're presented with no alternative. So in one of OIP's cases where we secured an exoneration, our exoneree, who did not commit the murder that she pled guilty to, was essentially presented again with bad science, bad evidence based on science, that was presented as completely unquestionable by the prosecution and by law enforcement. Her attorney did not contest that science, and she essentially was told, look, you either plead guilty and you'll go to prison for 10 to 15 years, or you'll go to prison for the rest of your life. Well, at that time, she was painted back into the corner, and so she ended up giving a false confession through a guilty plea because she was told by everyone, by law enforcement, by the prosecutors, and by her own attorney, that she had no other choice. Years later, once again, after much reinvestigation and actually doing some of the work that should have been done at the trial level, with looking at the evidence. In this case, it had to do with cell phone towers. Looking at evidence about whether or not a person's location can be reliably determined by a cell phone in their pocket, talking to cell phone towers or not. A federal judge looked at all of the evidence and agreed that she had been wrongly convicted, even on the basis of her false confession. There's also bad witness IDs. In a lot of cases, and this is actually the one that's the kind of elephant in the room, and with the National Innocence Network, they say over 70% of wrongful convictions involve bad identification. Currently, right now, we're working on a case where a person was convicted and is currently in prison on the basis of an identification by a drunk witness. Now, what we've determined is that there were other people there who were present who were not drunk, who all say that our inquirer was not the guy who, it was a stabbing, so it was not the guy who stabbed somebody. Once again, what happened is we had a bad witness identification along with a failure to investigate by the trial attorney, who the trial attorney failed to gather the other witnesses who were not drunk, who could have presented a counter-narrative, and instead merely went to trial on the basis of trying to suggest that the drunk witness was unreliable because she was drunk, and simply that. But yet, it's clear to us and through our investigation that there's 3 to 5 other people that clearly saw the stabbing who were also not drunk. There's also official misconduct, which is present in a lot of wrongful convictions. The classic official misconduct aspect that is present oftentimes has to do with agents of the state or officials of the state not abiding by some of their duties and things they're supposed to do in criminal cases, such as if they do have evidence of innocence, what we call exculpatory evidence, they're required by the Constitution to hand that over to the defense team. Unfortunately, that does not happen in some cases. We also see cases where the state lab has failed to provide evidence to the defense, has failed to provide forensic evidence to the defense that would tend to show that would tend to show innocence, and only providing the evidence that would tend to show guilt. That's, of course, a problem that OIP here in Oregon works on frequently, and frequently is a problem that is presented to defense attorneys, where the state will oftentimes depend on the kind of the scientific credibility of the Oregon State Lab, arguing and maintaining that they're kind of independent, neutral scientists merely trying to figure out what actually happened in situations, when what is clear again and again is that the Oregon State Lab works as experts mostly for the prosecution and for law enforcement. And what they do is they don't just look at situations and try to figure out as much as scientifically possible about that situation or about that case to present to a jury. Instead, what they do is they answer investigative questions that are posed to them by the detective. And so, in so doing, frequently what they will do is they will answer the investigative question as posed to them by the detective, even though there's other evidence that gets discovered that would tend to undercut the prosecution's case. The final cause of wrongful conviction that we find a lot, which I've talked about again and again, is in most cases involving wrongful conviction, there has been a breakdown in the defense function. So oftentimes what we see in innocence cases is we see an ineffective assistance of counsel, where the person and the group of folks that were meant to be the defense attorneys, that were meant to stand on the side of the defendant, of our inquirer, have failed in their jobs to fully investigate the case or to fully secure experts to look at and test the prosecution's evidence. Those are the causes that we see in a lot of our cases that are present when folks get exonerated. Now, I'll just briefly say that OIP works on these cases really for 2 reasons. One is we look at correcting miscarriages of justice in individual people's cases, because of course it's important to them, their families, their communities. And then also, in these cases, we oftentimes see examples of larger systemic problems that occur in the criminal justice system, and that we can use these cases both to correct individual injustices as well as to understand ways that we need to make the criminal justice system better. And with that, I think I would invite up Lisa Christian. Kristen, who is a volunteer attorney with the Oregon Innocence Project, and she lives here in Lane County, and I look forward to hearing from her.
Good afternoon. Again, my name is Lisa Kristen, and I want to thank you all for having me here today. I was at the City Club once before. I ran for school board, and I lost. But you were all very nice to me, so I wanted to start with that. One thing I just want to touch on really quick about something Ken said that I learned after I joined Innocence Project that was fascinating to me. Had to do with bite mark evidence. It's one of those types of science that, you know, if you watch as much Law and Order as I do, you think it's bulletproof. It's not. And I remember, I think it was Brittany Plesser, one of our attorneys, that pointed out to a group that it's, you know, first of all, everybody's getting dental care in the United States. We all pretty much have the same teeth to an extent, and it's not the, again, bulletproof science that I guess I had always believed that it was. I haven't worked on any cases involving bite marks, but I thought it was kind of fascinating to add on to what Ken was saying about things that maybe in the past have been perceived as rock solid, simply is not the case, and we're learning more and more each year about that. So I'm a volunteer staff attorney, and I've been a volunteer staff attorney since 2018. It's pretty telling about how weird the last couple of years have been that this is the first time I'm meeting Ken in person. We've seen each other on Zoom quite a bit, so he's seeing both halves of me today for the first time. So my experience with the Innocence Project began, I just reached out to Steve Wax, and he was one of basically the creators, a former federal defender for the state of Oregon for, I believe, 30-something years. And I reached out and just said, you know, I'm really interested in volunteering. What is it you do? And I felt like Steve might have been looking at me a little suspiciously because I told him I'd been a prosecutor for most of my career. So I met he and Brittany, and they invited me to join as a staff attorney. I fully believed that I would be stuffing envelopes or calling people for fundraisers. Instead, happily, they gave me a case pretty much right out of the gate. This case involved one of our clients who was convicted in Deschutes County. And when the case was tried, at the time I received the case, the person was in jail, was in prison. And we had in the trial transcript the miraculous objective fact, provable or disprovable fact, which you very rarely get in cases, especially this was a sex case. Usually that's, a lot of one person says one thing, another person says another, and you don't have objective facts to look to. In this case, we had a statement from a key witness at the trial indicating that a certain animal, a family pet, had been shot and killed. And that did not happen. So they assigned me the job of finding out, A, does the dog still exist? Is the dog still alive? Which was a concern. The trial had happened some time ago, and the dog at that time was an older dog. So we had a little bit of a time crunch. I have to say that happily, John Hummel, the district attorney for Deschutes County, assigned an investigator to this case in the sense that he wanted to ensure the conviction was valid and that all T's had been crossed, I's had been dotted. Culminated in myself and an investigator with the Deschutes County DA riding around in his Dodge Charger, literally around the state of Oregon looking for this dog. We had some leads, so we did knock on a lot of doors in Bend and Sun River. I almost scaled a fence once until he, talked me out of that, looking for the dog in the yard. Eventually, the current owner of the dog had changed hands twice, contacted us and was living out in Gerhardt, out on the coast. So we took a trip out to the coast, met the owner of the dog at a golf course, and the drum roll and sappy music. We walked around the corner, and there was the dog, sitting there drinking water. And we played with that dog. We took about 1 million pictures of the dog, rubbed its belly, chatted with the owner, and then drove back to Bend. We presented our findings to the district attorney. We had a chain of custody, there's a little bit more involved, that we had a chain of custody of the dog. There had been a certain vet that had taken care of this dog through most of its life and recognized the dog, a very unique looking animal. And we had witnesses, we had talked to witnesses about the ownership of the dog and had attempted to talk to the person who had made the statement about the dog being shot, but that didn't pan out. And much to our delight and again, doing the correct thing, the case was dismissed. So our client was freed. And I believe that was our first exoneration with the Innocence Project. Again, through sheer dumb luck, I got to be part of that. So I was very, very happy to be part of that, to be part of the group. The DA acting in that way was somewhat of an unexpected assistance to our efforts and to our cause, which again, I think bears repeating simply because this was someone who was invested in, again, in making sure that the right thing was done. The conviction would not be upheld if it was not warranted. And again, the sheer luck of having an objective fact to either prove or disprove. I can tell you in my years, I've been practicing since 1992, I've had very few cases where there were singular facts that were so important and again, so able to be ascertained one way or the other. It's usually a little bit muddier than that. Other cases I've been involved in, and just day-to-day what I do as a staff attorney, involve less travel, although I did go to Medford and count the steps from a donut shop to an alley. I wanted to see if a witness was telling the truth, and I just couldn't get my mind around it, so I drove down there and literally counted the steps and then sort of measured it with my car to make sure that I was clear on how long it would take to get from this donut shop to this alley. That was one of the cases. Another case, when I say we, I'm usually working with students that are also working with the Innocence Project. And, we've driven around, we've run the gamut from memorably being invited into somebody's house and being treated with Christmas cookies and cocoa. We've had the door slammed in our face many, many times. I've had the phone hung up on me. Most of what I do is I look through the cases that are assigned to me and go through everything I can using, again, my experience. Most of my time as a lawyer has been spent as a prosecutor. And looking at it from that perspective and determining what did the witnesses say? What did the witnesses, again, I'm probably echoing what Ken had said, but looking at what the evidence was, looking at whether or not there was a confession, looking at the circumstances of the confession. One last thing that's interesting, and I explain this to people when we talk about doing innocence work, I have taught appellate advocacy. I taught at John Marshall Law School. I taught a little bit in Idaho. I did appeals in Chicago when I first started working. So for me, one of the foundations of innocence work is to look at it not as an appeal. Everybody will say, and sometimes I'll hear people say, well, they've got appeals. So, what's the harm if they're sitting in jail and they're, innocent? I have actually heard people say that very thing. I'm not paraphrasing to my horror, but in any event, what I have said is, appellate work is completely different. You're looking at the trial. You're determining whether a mistake was made. Was it a reversible error? Was there a constitutional issue? Was there a witness who didn't appear? Was there evidence withheld by the prosecution? All the little minutia of what a trial is and what a trial isn't that goes into the mechanics of the trial. Innocence is there a path to innocence for this particular client? Did this person commit the act they are convicted of doing? Completely different and many ways much, much harder to get at. So in conclusion, I've been doing this for a couple of years. I'm very, very happy to be a part of this. Like I said, I was thrilled to happily fall into a notable case and all of the cases that I'm assigned. I give them the same weight and the same cursory look, or excuse me, not cursory look, in-depth look, where maybe before, like I said, with an appeal, there'd be a cursory look of a transcript or of a piece of evidence. I try to do in-depth work that would lead to determine whether or not there's innocence versus, again, an appealable issue. So again, thank you all very much for having me today. It's been a pleasure.
Thank you, Kenneth and Lisa, for joining us at the City Club of Eugene today. We'll begin our Q&A with the Oregon Innocence Project in just a moment. But first, I would like to thank some of the business and in-kind sponsors who make City Club possible every week. Thank you to our Sapphire sponsor, Summit Bank. Support for the City Club comes from Summit Bank, your local community bank, an independent community bank headquartered in Eugene. Summit Bank serves businesses and professionals in Eugene, Springfield, and Central Oregon communities, and you can learn more at sbko.bank. Thank you also to today's gold sponsors, Network Charter School and Homes for Good Housing Agency, as well as to our in-kind sponsors, KRVM 91.9 Radio, PAC Info and Simplified Computing, LLC, and Dotson's Photography. Finally, also thank you, a special thank you every week to our award-winning public radio station, KLCC FM 89.7, for airing City Club programs on Mondays at 7 p.m. For those listening right now to City Club, your household is one of several thousand that are tuning into this program. We hope you love what you hear and that you will talk about it with your community members and neighbors. You can find all recent City Club programs archived on KLCC as well as on our YouTube channel and as podcasts. We'll take a brief break and return with Q&A with the Oregon Innocence Project. Welcome back to the City Club of Eugene and today's program, Guilty Until Proven Innocent, the work of the Oregon Innocence Project. I will now invite Joel Corin back to the microphone to introduce our first questioner today.
The speakers are a little concerned because the first questioner is Professor Garrett Epps, who teaches constitutional law, and they're afraid of a law professor's questions. So, Professor Epps.
First, I want to thank these speakers for a really valuable performance, presentation of something that's very important, and also for outlining the pilot episode of a really terrific new TV show, Paw and Order. And I think I just see the ratings right there. But on the serious note, I want to say, I think that everybody in this room, everybody who everybody who hears your story of what's going on, would agree that it is a very basic failing of a criminal justice system that it regularly produces false confessions or false convictions. And my question is, not all of us are lawyers, not all the people can volunteer to take the time to do these things. What can we here do, just as ordinary citizens, not necessarily lawyers, to not only help your work at that end of the process, but try to make sure there's less input? What changes in the system would really help reduce the frequency of false convictions?
Well, that's a really big question. And so our fears were justified. I mean, there's so many things that people can do, individually. Right now, a large part of my job is working with volunteers because, hundreds of people have written OIP. We have a backlog that we're struggling to get through. And, we are a small nonprofit law office. I'm full-time. I have a full-time staff attorney. There's a couple other attorneys at OJRC that take cases, and so I have some of their time. So a lot of the work that we're able to do depends on people like Lisa and law students who are interning and externing and getting credit oftentimes. There's one of our law students who will be a law student for a year this coming year at the table over there, and other volunteer counsel. And right now, one of the things that I've been experimenting with is getting more volunteers. So I've been getting folks who do not have a legal background to come in and volunteer with us. And they've been doing some really great work that I think has both been interesting for them, opening their own eyes to some of the criminal justice system, as well as producing some good results and some really good work that can actually help people who are currently in prison. So of the volunteers that I have right now that are not investigators or lawyers or whatnot. I have, 2 people in their 20s who are both an undergrad at Portland State University, because our office is up in Portland. And then I also have a retired principal. And what they've been doing, one of the big things that's happened in Oregon in the last couple years has been we've finally succeeded in getting rid of non-unanimous jury verdicts. So Oregon was one of only 2 states in the country that allowed people in felony cases, non-murder felony cases, to be convicted on a non-unanimous jury verdict. I've been a lawyer since 2006, and so for that entire time have been making arguments that is violative of the U.S. Constitution, along with other lawyers that have been making that. And in just the last few years, in 2020, the U.S. Supreme Court finally said that yes, non-unanimous jury verdicts that would occur in Oregon and Louisiana are unconstitutional. And so what that means, though, it means that we have thousands of people in prison on the basis of non-unanimous jury verdicts. So what the three volunteers who are not lawyers have been doing is they've been looking through our old cases and our cases to identify the folks that have non-unanimous jury verdicts, to make sure that they're aware of that change in the law, and to offer them resources and ways to deal with their convictions, some of who are in prison right now. And that's interesting work. It doesn't require a lawyer to do, but it does require a lot of people hours, because there's no box checked in the file somewhere that says non-unanimous jury verdict or not, or sometimes if there is indication of that, it may not be accurate. It's taking individual volunteer hours to go through all the files, look at the trial transcripts, look at appellate briefs, look at post-conviction relief filings, look through the process and look through all of the papers and try to figure that out. And that will result in, I can say with 100% certainty, that's going to result in an actual change in somebody's life, right? In somebody getting that felony conviction off the record or getting released from prison. It will definitely happen. So that's one thing. Another thing people can do is, what is the innocence work? Well, innocence work is concerning because innocent people shouldn't be in prison, and because the problems that happen in cases happen in other cases, right? The problems that we see in our cases are reflective of cases as a whole. But in my opinion, a lot of what's happening is the innocence work is just a symptom of the natural outcome of some of the political and social processes in this country that have resulted in over-incarceration. And so what folks can do is they can be concerned about issues like this, talk about criminal justice, talk about the problems of over-incarceration, over-criminalization of behavior in our society, talk to their friends and family, talk to their politicians, their community leaders, groups like this. And, Oregon, we have to do something to stop over-prosecution. The public defense system is breaking, or is already broken in Oregon, because too many cases are being filed. If there's problems in our society, we need to figure out a way to deal with them without just throwing the penal code at it. And how do we change that? Well, that's a big question. It's a big systemic change, but the folks in this room and listening to this radio show are change makers. They're folks that are thought leaders in the state, and you can talk to legislatures, and you can talk to professionals in your life, and you can talk to your friends and family, and try to figure out a way to deal with that issue.
One thing I'd add that I do regularly and try to promote to my friends is Oregon Justice Resource Center is sort of the umbrella agency which OIP lives under and within. But they have regular fundraisers. They're part of the Willamette Week gift guide, giving guide every year. So keep an eye on that. You can always donate. I got some great coffee mugs this year that say Innocence on them from OJRC. And the second thing really quick is I know I have gone to the legislature on behalf of OJRC, but again, everyone in this room can reach out to their representative and say, on issues that are coming up before the legislature that impact innocence work. You can go to the website for OJRC, OIP, it will lead you to OIP, details what those legislative proposals currently are. I was involved in the Measure 11 reform as it relates to juveniles, and it was just wonderful, empowering to be able to speak to, provide testimony to the legislature and just hear all the other voices that were coming together to do the same thing. So again, I felt that was a very powerful way that the state of Oregon, if you will, spoke as a group and said, let's stop treating kids like adults right out of the gate. So those are the two things I would recommend.
And of course, just so everyone's clear, what Measure 11 is, it's Oregon's law that's a one strike and you're out law, essentially a mandatory minimum prison law that provides a mandatory minimum prison for a large range of, violent felonies or sex felonies.
And its application to juveniles was pretty significant. Working as a juvenile prosecutor, oftentimes we'd get a police report, and within literally 5 to 10 minutes, because something needs to happen, a decision needs to be made, these kids might be being tried as adults in situations that maybe didn't warrant it. When I lived in Chicago, the way we did it was we waived kids, out of juvenile court only if there was a hearing and a judge weighed in on it. Because of the reforms that have happened here, that is now the law in Oregon as well, which again I think makes a huge difference when you're talking about making a decision that's going to affect a juvenile. Anybody over 15 is committed, like Ken said, a violent, I'm paraphrasing here a little bit, but a Measure 11 eligible offense could be subject to adult court. At the age of 15, again, now it's a little more even-handed because the judge is going to weigh in on that decision.
Next question.
Thank you. My name is Sharon Reed, City Club member. My question, I'm curious, how has current or emerging technologies been of benefit to your work?
So many ways, so many of the innocence cases that we see involve bad science, like I've been discussing. So, what's a good example? So everyone here has heard of shaken baby syndrome, right? And there's this whole class of cases in the criminal justice system that are oftentimes referred to as shaken baby syndrome cases or shaken baby cases. And these cases generally arise when you have a caretaker of a baby who knows and taking care of that baby, and then the baby is later taken to the hospital and is diagnosed with having certain injuries that 10 years ago science would say was only attributable to somebody must have shaken that baby, that is violently accelerated and decelerated the baby and caused these internal injuries. And that's what science, that's what many scientists and many medical professionals believed is the only potential cause for the injuries that were found in shaken baby. And there's hundreds of people who are in prison right now because they were babysitting or taking care of their child or somebody else's child, and that baby went to the hospital and reported with certain injuries. Tragic cases, some of the worst cases. Well, the science has changed in the last 7 years or so, since like 2018. The change in the science from the American Medical Association has said that no, there's actually other scientifically and medically explainable reasons that would have caused those injuries in that baby, such as suffocation or short, relatively low falls. And so we have hundreds of people, and I don't have the numbers in my pocket, but hundreds of people who are in prison because the jury was told that this person must have knowingly injured their child, when in fact what medical science would say now is that some children could have had some of that same brain bleeding, some of that same injury, because they had been choking on like some puffs, choking on some of the baby foods, and when the EMTs came, there had been inappropriate medical care provided to the baby in the EMT and kind of resuscitation process. Is this still a problem? Is it still a tragedy? Yes. The cases don't get more tragic than this. But what we know is that in the rush to justice, in a rush to explain that tragic problem, we had scientists standing up in court and telling juries who are trying to do their best, who are hauled out of their everyday life and placed in a traumatic situation and told to make a hard decision, that science demands that you convict this person, when that's not good science. It's not good and valid science. And so, we have all of these situations, such as shaken baby cases, where the rise in science suggests, and the rise in technology and further research suggests that a rush to judgment, a rush as a society for us to kind of cathartically purge some trauma, that was not based on good science. Similarly with DNA, right? DNA is getting better all the time, right? What you can find now in the last 5 years with DNA analysis is much more sensitive, is much greater, is much more precise and reliable than what you could find 15 years ago. So, like OIP has a case that we're going to win it. I mean, we've essentially won it. We're right now only discussing with the state what that's going to look like. and how soon it's going to happen. But some of the key evidence against him was they had a DNA expert get up and say that our client matches some hairs in a shirt or in a sweater, and that was in the late 90s, right? What we now know is what the DNA science would say is that 15% of all African Americans would have matched that DNA, or would have matched that hair. So 15 out of 100 people. Our client was African American in an African American neighborhood. But the jury 20 years ago was told, this is a match. DNA, gee whiz, this is our guy. What, you don't believe in science? Well, that's not actually, wasn't reliable. Part of the issue that happens in trial is sometimes some of the evidence, especially some of the scientific evidence that's presented to the juries, it's a form of drama in a way. And what we see again and again in innocence cases, as the march of science and technology continues, we see convictions where folks are still in prison that just can't be trusted.
I should point out that the national co-founder of Innocence Project, Barry Schenk, was a lawyer who basically pioneered the wider use of DNA evidence and went around the country teaching lawyers on how to use it and then acting as a great defense. It's proving of innocence, and it's gotten better. Andrew.
Andrew Kallick, President-elect City Club. Thanks for being here. My question is about a Supreme Court case last year where the justices ruled that even new evidence of actual innocence does not require a new hearing, even in death-eligible cases. And my question about that is, how important are state constitutions to the work of innocence projects around the country? And have we seen any innocence projects leveraging state constitutions to bring additional claims? Thanks.
Well, as the U.S. Supreme Court closes the courthouse door more and more to litigants raising innocence claims, of course, litigation in state courts and state constitution will become more and more important. We can see that in the law right now. So in the law of Oregon, the federal standard for actual innocence isn't perfectly defined, but I could tell you what it is. Right? I could describe to you what the case law says is the federal standard for actual innocence. We currently don't know exactly what the state standard is. And those cases are being litigated more and more, and we're trying to demand that the Court of Appeals and the Oregon Supreme Court tell us what the state constitution, what Article in Section 16, which is essentially our cruel and unusual punishment provision, what that means in innocence work. And, the interesting thing is your question's like a very lawyerly question, and it's one that's near and dear to my heart as kind of a lawyer, a legal nerd. But one of the interesting things about OIP's work is when I get a case and we look at cases, we don't actually think so much about legal procedure, right? What we think about is factual innocence and actual innocence. And we oftentimes will heavily investigate a case and try to figure out, as Lisa described, if we can find a legal path to innocence. And if we can find a legal path to innocence, the procedural mechanism doesn't really matter, right? Maybe we go to the federal court, maybe we go to state court, maybe we call the governor's office, maybe we call the prosecutor. It doesn't matter in some ways, procedurally, what mechanism we have. Because if we can actually prove innocence, we have an actual factual path to innocence, we can try to demand that the system abide by that and recognize and protect and honor people's innocence. Because hopefully people can disagree about all sorts of things throughout the political spectrum. But one of the nice things about innocence work is hopefully it's something that we can all agree on, is that innocent people shouldn't be in prison.
Let me interrupt a second. Lisa spoke about the cooperation with the Deschutes County prosecutor. What has your experience been statewide?
I'll let Ken answer that more fully, but I think that's a great point. In fact, that's why I was grabbing the microphone, was to say, I do think one of the avenues maybe of pushing back against what you're describing is happening with the court system is to look at the people who are actually trying the cases at the front end and say, how can we educate people and how can we help people? How can we get more progressive DAs like the DA I mentioned that are looking at these cases and looking at it from a standpoint of, you know, are there questions here? Are there concerns that this person did not commit this crime that are outside of maybe any constitutional ruling or consideration? So I think part of our role, I know part of what I feel my role is to, you know, educate people and help people understand there is a place for everybody, you know, at this table, and that includes prosecutors, that includes people who are making the charging decisions, it includes the police, you know, at the very beginning level of that. So I do think we got very lucky to have that prosecutor who, like I said, was very invested in making sure that the right person was, you know, behind bars, if you will. But we have to do more, and I think that is a way of pushing back against court rulings, would be starting with the people who are making the decisions.
Next question. Roz?
Okay, Roz Stein, City Club member. First of all, thank you for being here. Really appreciate it. I kind of got stuck way back wondering, are there any repercussions for the defense attorney who didn't really adequately serve the client? I mean, is there a censure? I mean, have they take any responsibility for the error that they made? That's all. Thank you.
There are some repercussions. Of course, you know, lawyers are professionals just like, you know, other professionals, and can be liable for malpractice civilly if you can sue them, although that's difficult. The state bar, certainly, there's ethical requirements of diligence that sometimes get involved. You know, but the fact of the matter is sometimes when trauma happens in life and bad things happen, and one of the things that happens with society, with the court cases, is when presented with this trauma, when presented with these bad things, there's this quest to find like a bad actor, right? And I have to admit that in my prior comments, I probably played into part of that by pointing some of the fingers of the defense attorneys. And don't get me wrong, I've had cases where I can say this defense attorney, what they did was almost criminal or should be criminal, because what they did, they didn't care. I've had other cases that I can point at and say, you know what, this wouldn't have happened if the defense attorney would have done something differently. But, you know, a lot of what we do is kind of backseat driving, and the defense attorney oftentimes, you know, has a difficult job, limited resources available, and is trying to do the best that they can do, right? So a case that we're looking at right now that probably would have turned out better. He probably would not be in prison if he had had different counsel. You know, one of the main things, you know, in looking at a case and trying to figure out how the system failed, right? You know, he had an attorney who found, you know, there was probably 5 witnesses that should have been brought in that would have, if presented, I think probably would have resulted in a finding of not guilty, right, in innocence. Although, of course, I can't say that for sure because they didn't give me a crystal ball, but it sure seems like it. What the defense attorney did is they had their investigator find one of those witnesses. That was a good witness. I've read the transcripts. I was like, I see why this is a good witness. Presented that single witness to the judge. It was a judge matter, not a jury. And just didn't win. And that defense attorney, after talking to him, agrees with me that, you know, he shouldn't have stopped. He should have gotten the other witnesses. And it's the case that he lives with when he thinks of things that should have gone better. Unfortunately, while he feels bad, his client and my inquirer is sitting in prison as we sit in this nice room having this conversation. So there are mechanisms in society to kind of push back and try to censure bad defense attorneys. There's certainly more mechanisms in society to hold defense attorneys accountable, more than there are prosecutors accountable, in my opinion. We could talk more about that. But there's a lot of facets to that particular issue.
Unfortunately, do you have anything to add? Unfortunately, we've run out of time for questions, so we will now call on Karen Knutson. on back.
Thank you, Joel, and thank you all. This has been our March 17th, 2023 conversation at the City Club of Eugene, Guilty Until Proven Innocent, the work of the Oregon Innocence Project. Before we thank our speakers one last time, I would like to recognize City Club's Diamond sponsors and thank them for their support of our programming and our work. Kaiser Permanente exists to provide high-quality, affordable healthcare services and to improve the lives of our members and the communities that we serve. You can learn more information at kp.org. The University of Oregon has helped Oregonians to question critically, think logically, reason effectively, communicate clearly, act creatively, and live ethically since 1876. And you can learn more information at uoregon.edu. Peace Health has been proud to serve Eugene, Lane County, and beyond as your hometown healthcare partner for more than 80 years. The Peace Health mission is to keep you and your family healthy, and you can learn more at peacehealth.org. And Lane Community College transforms lives through learning. LCC provides comprehensive, accessible, high-quality educational opportunities that promote student success, and you can find more information at lanecc.edu. Thank you also to the City of Eugene and Lane County for their support. Next week, on Friday, March 24th, join us again at the 5th Street Market District as City Club hosts a candidate forum for the upcoming Ward 7 City Council race for Eugene. Candidates Lindsay Leach and Barbie Walker will attend, and KLCC's Brian Bull will moderate this candidate forum. The following week, on Friday, March 31st, we will turn our attention to the garden, to Green Thumbs, Intergenerational Food Science, and the extraordinary work of 3 local gardening organizations, Huerta de la Familia, Grassroots Garden, and the School Garden Project of Lane County. Hope you will join us for this event and get inspired in your own work. We also invite you to become a City Club member, a sponsor of our work, or to suggest an idea for an upcoming City Club program at cityclubofeugene.org. We welcome everyone to participate in and offer their input to our community conversations. Thank you again to the Oregon Innocence Project for joining us today at the City Club of Eugene. It's been a pleasure to welcome you here. Thank you all for joining us. Take care, and we will see you again next week.